Okay, we would like to welcome all of you folks here for the first edition of the Builders Exchange's legal webinar series. And with us is Alex McCallion from the Brennan Manna Diamond firm, excuse me. And Alex is in the Canton office. He's a Stark County native and graduated from Walsh College. Is it Walsh University now?
Yeah.
It's Walsh University now. And then went on to get his Juris Doctor legal degree from the College of William and Mary. And he is a partner with the law firm. So without further ado, Alex, you want to start the presentation?
Yeah, thanks, John. So everyone, I know I can't see you, but you can see us. So thank you for attending. What we want to do with this legal series is just give everyone a brief 30-minute overview of specific legal topics to make sure that you are aware of them. Well, we don't want to give a discourse on every little thing, or John and I could talk at you for hours, which you probably would hate. So what we want to do is just with this one is make you aware of certain contract clauses that many of you have seen before, or maybe you've signed off on without thinking about, that if a project goes sideways, can really impact the entire project from start to finish, and then cause a lot of headaches with arbitrations or lawsuits afterwards. So what I'd like to do is just go ahead and get started. And John and I are going to do a little bit back and forth between telling you the legal principles and then kind of trying to give you examples without telling you which clients it was, but give you examples of what can happen when you sign up for this type of contract clause and it goes sideways.
I guess I should say also, Alex, that for perhaps some of the participants here, that I'm the executive director of the Builders Exchange and have been associated with the Builders Exchange for quite a while. And I'm also a lawyer. So that's how Alex and I have a relationship in that regard.
Yeah, so sorry, I thought everyone on the call knew that. Yeah, John, in addition to being the head of the BX, is a longtime practicing lawyer. So he has decades of experience over the exact things that we're going to talk about. So in addition to being your executive director, he also has tons of practical experience dealing with these exact problems. So the first one, it's what happens if you have poor forms? What happens if you just sign off on whatever's put in front of you? Typically, whatever's put in front of you first, whether it's from the owner, a general contractor, it's going to be one-sided in that party's favor, and it will shift all of the risk to the other party. Another thing it can do, when I say on this slide, it can create an adversarial relationship. Sometimes if you encounter a problem early and it's the first time you're reading a contract, you realize that your partner in the project, whether that's the owner or the GC, has shifted all the risk of anything bad to you, which at that point, it just creates a project that will end up being a paper trail of blaming one side or the other versus doing what you're supposed to do, which is try to get the project complete. It can make for longer, more difficult projects and an awful work environment. And one of the worst things it can do is at the end of that awful project, it can stop you from recovering damages for what may have happened. So we'll go into detail more on this as we go through them. But the first one, it's something that is nearly always near the front of the contract. It's one of the first things you'll encounter on site. It's differing site conditions. So for those of you that read contracts regularly, this clause typically says that if it's the contractor, the owner is the general contractor is representing to the owner that they have looked at the site conditions, they've looked at the soil, and they are satisfied that everything is correct and that they can do their job. If you're a subcontractor, it will contain a similar clause that says you as a subcontractor have looked at it and are satisfied that you can do the entire project just like it's bid. And that includes unforeseen or concealed or subsurface conditions. So here's an example is what happens if you're on a project and you're building a building and there's unsuitable subsurface soils and your building starts sinking. Well, what do? Everyone will want to blame someone else. And first thing that you do is you go back to the contract and says, all right, does it have this clause? And if it did, you as a subcontractor may have unknowingly accepted the risk for a building sinking. Before going, John, do you have questions?
Well, yeah, that's that's the nightmare situation right there, where the problem arises with site conditions. I guess the question would be, what you're going to argue about here is, did you, with the duty to inspect, were the conditions unforeseen, right? I mean, could you have, if you failed to inspect, and if you did inspect, could you have found those conditions, or is it truly unforeseen? Now, we don't want to get too far in the weeds with legal principles here, but there's also a principle that is called superior knowledge. Okay, and a lot of times the owner is going to have superior knowledge, right, instead of the contractor. So as a contractor, that's one of the things when site conditions come up, to keep in our argument here, is that, hey, listen, you had the superior knowledge here and you didn't disclose it to us. So but that is that's a clause in there. So you're going to have a duty to inspect before you commence your work.
Yep. And the duty to inspect, what we recommend is not only do you inspect the soils, go look at the engineering reports. So if you're going to have a clause in here that says you're agreeing that the soils and the subsurface conditions are adequate, go look at the engineering report to see if there's anything disclosed in there. Because if there is something disclosed in the engineering report and you didn't bother to read it, it's going to be tough to argue that you're not bound by a clause like this. So doing a little bit of due diligence on the front end with the engineering and looking at the site can save you a monster of a headache on the back end. Because John and I have both encountered this with, and if you're building an entire building and the surface soils are inadequate, it can get very expensive very quickly.
Yep.
So the next killer clause that many of you have probably seen and a lot will not understand or have never read thoroughly is indemnification. So indemnification basically is a risk shifting provision that will shift all the risk if you do something wrong, whether it's negligence or faulty performance, you must indemnify the other party. So if you're the subcontractor and you do something negligently, oftentimes you'll have to indemnify the general contractor for a broad variety of things. And basically what that means is you are on the hook for all of the expenses. So if you do something wrong and the general contractor gets sued for it, and there's an indemnity clause, it means you're paying for whatever the damages are, you're paying for their legal fees, you're paying for any out of pocket that they may incur. Oftentimes there's a lost profit clause included in there. And most of the time when you get the contract the first time, the lawyers will have put in what we call a unilateral indemnification. That means that you're indemnifying them, but if they do something wrong, that may not be mutual, where they will indemnify you. So that's something that we always try to add in to the contracts. And when I say this is common, I had 4 contracts this morning already that I looked at, and all 4 had a unilateral indemnification that we had to turn around and say, all right, well, if you want us to indemnify you, you have to indemnify us if you do something wrong.
Right. Mutual indemnity.
Yeah.
You would want, right. And I would say, Alex, also the larger and more sophisticated, the general contractor, construction manager at risk, they're going to have those unilateral, really one-sided indemnification clauses. And Alex and I discussed this before we started here, and that is, much of your ability to perhaps negotiate out some of these clauses, I guess, depends on your strength as a subcontractor. How bad do they want to use you, and approaching them and reading the contract, or having your lawyers take a quick look at it. Maybe you can have some pushback, so you protect yourself. You get mutual indemnity, just not unilateral indemnity. Yeah.
And the easiest argument that I make when I'm asking for mutual indemnity is, well, if you want us to indemnify you, it should go both ways. If we're going to be partners on the project, if I screw up, I pay for it. If you screw up, you pay for it.
Right.
And go with the partner approach rather than just trying to argue with them.
Right.
And another negotiation tactic with this is to try to limit the scope of indemnification to only negligent acts or only paying for third-party claims. Sometimes it will be for any negligent act. If you're even, say you're 1% negligent and the other party's 99%, it may still say that you have to indemnify them. So it's just something you need to be aware of, and spend the 5 minutes with your lawyer to look at it ahead of time or explain it to you in greater detail when looking at one, and it may save you a lot of headaches down the road. Another one that I know all of you are familiar with is change orders. So change orders are standard. There's nothing wrong with the change order. But if you were to ever look closely at the AIA standard contract documents, they contain a lot of what I call gotcha provisions with respect to subcontractors and mainly with field directives. So it will have a whole provision for change orders. But what you may have experienced is if you don't agree on the scope of the change order or the price of the change order, whether it's an increase or a deduct, the other party, so usually the general contractor, can force you to do the work under a field directive.
Right. So I think, Alex, then you want to, if you're bringing a proposed change to the contract to either the owner or if you're subcontractor to the prime contractor, you've got to be proactive about this. And if you've got an AIA contract, there's timeframes within that AIA contract within which you have to present your change order. Okay, so the project just doesn't bump along, and the general contractor would say, you're way late in bringing this change order to our attention. So you've waived your right to get additional compensation for the change. So those are some things to be aware of, particularly with the AIA contracts, right? They're going to have, there's timeframes all over the place in those contracts, and you've got to be aware of that. Okay. And that involves notice, right? The concept of notice, where I once was talking with one of my clients who, bigger contractor, and he said, well, John, I look at it as you can never give too much notice. Okay. And perhaps some contractors or subcontractors, they don't want to start giving a bunch of notice because it's going to kind of maybe spoil the relationship a little bit. You know, you're being a pest. Come on, just do your job and all that. So there's the interplay there. But I think there is a point that you can never give too much notice, right?
Yep.
Good.
Yeah. And another thing that can come up with change orders that I don't know if anyone has experienced this, but if you get issued a field directive and say you don't agree on the dollar figure of a change order, so they give you a field directive. If you later sign a change order for that field directive, if you don't reserve the right for your claim and you just sign off on a change order later for, say, if the contractor says, hey, I'm not giving you the money for this field directive until you sign this change order, you can waive all the extra money or time that you're asking for by signing a change order without reserving your right to seek additional money. So a very savvy owner or owner's rep usually will try to get you by doing that is, all right, we'll issue a field directive now, and then in 3 months they'll issue a change order, and you can end up waiving the extra time or money you're trying to claim.
Right. So of course, the oldest advice in the book is that you need to put the notice, anything else in writing. Okay. Email's a great thing.
Yep.
Can be almost abusive, right?
Yeah.
So that's right. You know, let's get it in writing, even for the email. Okay.
Yeah. So yeah, call them, explain to the other party to answer this question. Call them, explain what you're doing, saying, hey, this, I can see this is going to be an issue. Here's why. And then follow it up and say, hey, this is what we're asking for. Here's why. Here's when we think it's going to be an issue. And that will also, the sooner you can do that, the better, because then it shows that you're being proactive and you're not trying to stick someone with a change order and say, oh, look, I found this issue. I can make a lot more money on it. It's a, no, here's an issue. And then in an ideal world, you can proactively figure out a solution that everyone agrees on and sign your change order.
Right.
So John previewed this one for you.
Right.
Claim notice. So the AIA contracts, if you guys work off of those, are full of notice requirements. So the standard AIA contract, for example, says if I believe it's 21 days. If you encounter an issue that's going to lead to a claim, you have 21 days to notify the upper level party. So whether that's the general, the owner's rep, or the owner. And if you don't, you can waive that claim. And there's some case law out there where the provision was narrowed to as short as 7 days, and the claiming party didn't get the notice in writing to the other side within 7 days. And a judge in Ohio ruled, I think it was Summit County, said, you've waived your entire multi-million-dollar claim.
Yeah, so I guess looking at it from how this matures into a claim, you've got a change order, right? There's a change in conditions, okay, that one party's going to, where you're going to talk about, one party will present, and maybe the subcontractor is going to say, hey, we've got a change here now. We're entitled to additional compensation. You price it out. If you get into a disagreement with the prime contractor, or if the prime contractor gets into a disagreement with the owner, then at some point it matures into a claim, right, Alex? Okay. So that's the claim. When you pursue it for a claim, sometimes that's going to put further pressure on to settle the change order, and you can get an agreed change order, right? Or else and ultimately the claim can mature into dispute resolution, right? If you can't agree.
Yep.
Okay.
So to John's point, the key is notice. And you see, we have the question posed, when does a claim arise? Oftentimes you won't know it's a claim until months later, but the key is to put the other side on notice. Whether or not it's going to cost you any extra money, it's going to cost time, just put them on notice of it in writing. Obviously, we're lawyers, so everything in writing. But here's an example. Say you're a mason and you have a schedule, and you can tell that the structural steel and the cladding is 3-4 months behind. And you say, there's no way I can complete this because I'm going to hit winter conditions. Put the other side on notice. Say, hey, I won't be able to complete this on time. I can already tell. You guys have to pick up the schedule on whether you're structural steel or the facade, whatever it may be. Just put them on notice and tell them that, so that they are aware of the issue. Then if it becomes a claim, you can monetize the claim or say, hey, I told you about this 6 months ago. You owe me an additional 30 days on the project and X dollars.
Right. Change order could be for additional time, right?
Yeah.
If you're delayed and it's not your fault.
Yeah. So the key is just to put everyone on notice of the issues ahead of time, so that you don't risk having them waived.
Yeah.
So I think everyone is used to retainage. This isn't as big as some of the other ones. I mean, every project has retainage. There are some contracts where the general or the owner uses retainage essentially as a sword and tries to keep as much retainage as they possibly can until the end, and then try to nitpick and fight with you over issues and holding your last 10% or so. So there are mechanisms to reduce this if you encounter that more than once and you say, hey, I've worked with this GC or this owner before. I know they're going to try to stick us on the retainage at the end. You can try to negotiate on the front end. One is to reduce retainage as the project goes along. So it may be if you're 90% complete, they hold a smaller portion of retainage rather than 10% of the entire project. Another one is to say all the retainage gets released upon substantial completion, so they can't use. A fun one is when the owner or higher tier contractor tries to use a de minimis punch list to hold hundreds of thousands of dollars in retainage because there's a nail hole in a wall somewhere. So you could use mechanisms like that to, once you hit substantial completion, give me my money back, and I still have to complete the punch list, but you can't hold up 10% of the project funds for a small punch list.
Yeah, it's interesting. And some of the governmental bodies will have ordinances that have what I perceive to be unfair retainage provisions or ordinances. Like Akron, I don't know if they still do, but the city of Akron held retainage for a whole year. How about that? I don't know if they still do, but I guess I wouldn't doubt it. But just something to be aware of. Yeah,
and a lot of our comments are if it's a private project or if you are a subcontractor on a public project. Oftentimes in a public project, if you are in direct privity with the owner, you're not going to have a lot of leverage. They're going to say, you want the project, here's our contract, here's the terms and conditions, and if you don't want it, don't bid on it. So, but you still need to read it to be aware of those ahead of time, because even on public jobs, local municipality or the state may change the AIA general conditions that you say, oh, I've seen these a dozen times. They can still modify them. So it's worth the read through to make sure that they are the general conditions you're used to seeing, or it is the contract you're used to seeing. This is a fun one. Paid when paid.
Right.
So this is another way that a higher tier contractor will squeeze a lower tier contractor, is to say, you subcontractor only get paid when the owner pays me. And so what happens if, say you do your work and your work is fine, but there is a larger dispute between the owner and the general contractor, even if it has nothing to do with you, and the owner's not paying the GC, you don't get paid. And the GC can say, well, look, this contract says I don't have to pay you. And if it's a huge dispute, say the owner stops I'll give you an example. General contractor is running 6 months late on a project, and there's liquidated damages of $1,000 a day. The owner can say, hey, I'm not paying these next pay apps because I already know you're going to owe me more, so I'm not paying you. Well, if you're a sub and you were on one of those pay apps, that larger dispute may have nothing to do with you. Your work was perfect. The general can still say, I'm not paying you, sub, because the owner didn't pay me. And you could do a project, and if that dispute goes on for years and goes to litigation, it could be years before you get paid.
Right. So, and I would say, Alex, the big question at some point with that nightmare situation you just mentioned is whether or not you have the right to stop work. Okay. And that's a tough call, because that brings the price of poker greatly up, right? If you stop work. Okay. But now, one thing that Alex and I did talk about also, so you have this paid when paid clause. Okay, that means that they can withhold payment for you for a reasonable period of time. Okay, because they're not getting paid. All right. And the subcontractors lost this battle a number of years ago, when, oh, these clauses aren't fair, general contractor, because you got in a dispute with the owner, and now the burden is shifting down to the subcontractors, right? So, and you can say, I didn't do anything wrong. Well, but you got paid when paid clause, so you're going to be waiting. Okay, but that doesn't mean you can't file a mechanics lien to try to secure your payment, even though you're not getting paid right now, right? That's a whole talk for another day, another webinar topic.
Yep. Yeah. So you guys have all heard mechanics liens. If you're not familiar with them, we could give an entire other seminar on them. But there are timing provisions in those as well that are very, very tight. And if you don't get your mechanics liens done in time, whether that's 60, 90, or 100 days, 120 days, you will lose your rights to that as well. So if you think you're on a project where you're not going to get paid, if you don't know how to file your own mechanics lien, contact your attorney immediately, and so that they know the time frame and can help you get the mechanics lien filed, because that will at least protect that you will get paid eventually.
And mechanics liens are a particular right of contractors. So that's leverage. That's really your security in some ways. Good.
So another one that the next two slides will kind of dovetail together, and we're on to the damages portion of the killer contract clauses. And this is the way that through damages clauses is one way that parties can seek to minimize their risk so that they know the maximum risk. One of those clauses is essentially a no damages for delay, which they can't just say no damages at all for delay. But what a higher stream party will try to do is limit the potential damages that you could recover. One of the big ones is, if you're delayed, we'll give you time but no money. So obviously we know on a project, if you're on the project longer, it's going to cost you more money. You're going to have more overhead, office, you may have more man hours. But if you only get time for that, you're losing out. So if you ever see a clause that says we'll give you time but no money, you should try red pencil that as quickly as you can.
Yeah. And that's the one battle that contractors won in the state of Ohio. It's called the Fairness in Construction Act.
Mhm.
And the legislature and the governor said, listen, you can't have these no damages for delay clauses. They're patently unfair. Believe it or not, the state itself continued to use those clauses for a while. And it's just, I got into a fairly decent argument with them by why would you have this in your state contract still? So those are unenforceable, right? So don't get buffaloed to thinking you don't have any claim for damages if you're delayed, right? Good. Okay.
And one variation of this that they'll try to use is, it goes back to our notice where they'll try to, an upstream party may try to shorten the notice provision or put a time period within the damages clause that's separate from the notice provision that says, even if you told us about it, you still have a different time period to tell us how much money you're owed or what your costs are. So it's the time periods are a great mechanism lawyers have figured out to kind of skirt these illegal clauses to say, well, we're not outlawing, the clause is still in there and it's legal. We've just shortened your time period. So it's a lawyer created mechanism to try to trip up lower tiers. And then this is our last slide. And this consequential and liquidated damages are two separate concepts. Consequential damages would be your lost profit, your rental expenses, depending on where you are. If you're the owner, it could be loss of use of a project, could be your reputational damages for a delayed project. Consequential damages could go either way. If you are the party who was delayed and it took a lot longer and you've incurred the damages, you want that clause in there. So if you're the one that ends up going to be suing someone, you want it in there. If you end up being on the other side of it and you're the cause of the problem, you will love that consequential damage has been waived, because then they can't come after you for all their damages.
All right.
So depending on which side of that coin you're on, you could either love or hate a waiver of consequential damages. I will tell you, most public projects and in the standard AIA, there is a waiver of consequential damages. So that's the standard you start with, and then you have to try to negotiate it in. So
yeah, and so with liquidated damages, those are also referred to as predetermined damages if there's a breach, and many of the public contracts will have liquidated damages, as Alex mentioned, per day. Even if you miss a milestone, you could be subject to liquidated damages, $1,000 a day, 500, whatever the public authority puts in that contract that you bid on and you're performing. And the reasoning there is that it's impossible or very difficult to determine actual damages. Okay, take a school project, for example. If the delay is your fault, okay, you can't get materials to a project and you're getting delayed, they put you on notice that we're going to be you're going to be subject to liquidated damages of $500 a day or $1,000 a day, because how can you determine damages if the school can't open on time in September or August, right? So that's just an example. Liquidated damages for public projects, they'll have that clause.
And one thing to be aware of as a sub, you may not even see those in your contract. What you'll see is your contract incorporate the prime contract, so the contract between the owner and the general, and it will flow down to you.
Yeah.
So it's always good to take a close read of the general contract, the prime contract, because you may not even know that you could be on the hook for $1,000 a day in liquidated damages if you're the plumbing contractor and your work delays other parties along the project timeline.
Right, and if you're a subcontractor and the prime contractor has incorporated the conditions with its contract with the owner into your contract, so you're buying that, you have a right to that contract. Okay, so.
And I think John and I have both experienced it countless times that a client will come to us and they'll have a short 3-page contract and say, well, this is all that I agreed to. But then there's one sentence in there that says, oh, by the way, you've also agreed to all of the general conditions and the prime contract, and they've agreed to 300 extra pages of contract without ever reading them. And then John and I's job is to get copies of those and explain to them how they've waived their right to numerous damages for a delay, or they've missed the time period that they didn't know they agreed to because they didn't read the other contract. So even if you get a short 3-page contract, you could still be agreeing to a mountain of these clauses without ever knowing it if you don't read it closely.
Sorry about that.
Yep. Oh,
Well, it's
11:30.
our time is up. Yeah. Well, I hope this gives you, it was helpful and gives you a little heads up on what to look for in contracts here. And so our next webinar with Alex again is going to be on March 6th, and it's how to handle a project delay. So we hope you'll spread the word with your colleagues, and we'll see you again on March 6th.
And we have one more question. Oh, there we go. Not even a question.
Okay.
Yeah. And as always, if you guys have any questions on this was more of a primer to make you aware of these clauses. It wasn't supposed to be a make you an expert in negotiating them. So feel free, call John, call me, call your lawyer. Any construction lawyer is going to be familiar with these clauses and can help you negotiate them depending on your leverage. Right. And I just saw one. Yeah, Sarah in our office will get she's recording this and we'll send out a copy.
All right. Okay.
All right.
Have a great day.
All right. Thanks, everyone.
Thank you.